Donald Trump and his thoroughly weaponized Department of Justice are absolutely losing their minds over the fact that there are now multiple whistleblowers who keep leaking damaging information to Democrats sitting on various House committees and to members of the press about the deeply troubling and frankly alarming conduct coming out of Donald Trump's politicized and corrupted Department of Justice. And instead of doing the sensible thing, instead of actually stepping back and changing course, instead of looking inward and saying, maybe we should stop doing things that are clearly illegal and clearly unethical and clearly outside the boundaries of what a functioning, independent, legitimate Department of Justice is supposed to do, what are they focused on? They're laser focused on hunting down and identifying who these so-called leakers are. They want to find the messengers so they can destroy the messengers rather than reckon with the message itself. Rather than acknowledge that their conduct is precisely the reason people inside that institution feel morally compelled to go outside the normal channels and bring this information to the people who are actually still doing their jobs and trying to provide some form of oversight over a runaway executive branch. The most recent and, quite frankly, extraordinary whistleblower leak that has come to light involves what appears to be a deeply, deeply frivolous criminal case, a prosecution that the Trump regime is now pushing forward against the Southern Poverty Law Center down in Alabama. And this isn't just an outside observer saying the case is weak. This isn't just commentary from legal analysts or critics of the administration. The Southern Poverty Law Center itself has raised a whole series of serious and very specific red flags in actual court filings submitted directly to a federal judge, laying out in detail how numerous false statements have already been made about their involvement with confidential informants. False statements that appear in the underlying court pleadings and that have been made publicly, and false statements that, critically, are very easy to rebut. Not complicated, not subject to significant factual dispute, just flatly, demonstrably untrue based on easily accessible records and years of documented cooperation. For example, and this is really where it starts to fall apart in a pretty embarrassing way for the people who put this case together, Donald Trump's Department of Justice is claiming that the Southern Poverty Law Center never informed the FBI, never told local police departments, never notified the Department of Justice about the fact that they were paying local confidential informants in various situations. The DOJ is claiming the SPLC never disclosed these payments, never revealed the fact that they had an active informant program, never told the relevant law enforcement agencies that the Southern Poverty Law Center was deeply involved in an effort to infiltrate and gather intelligence on extremist groups that were involved or were actively moving toward very serious, very dangerous violent acts. That's the government's claim. That's what they went to a grand jury and told prosecutors to present as the basis for a criminal indictment of one of the most well-known civil rights organizations in the country. And the Southern Poverty Law Center's response to all of this is essentially, what on earth are you people talking about? Because the reality, the documented, years-long, extensively recorded reality, is that the SPLC has been working directly with the very same prosecutors who are now bringing this criminal case against them for well over a decade. For decades, in fact. They've been working as partners with law enforcement, whether formal partners or informal partners in various capacities, sharing information, building cases together, coordinating efforts. They handed over detailed dossiers to federal prosecutors and to the FBI and to local law enforcement. These weren't vague conversations. These weren't casual tips. These were comprehensive, organized packages of intelligence information that directly led to actual criminal prosecutions of dangerous extremists. And they were done in full cooperation with and full disclosure to the relevant law enforcement agencies. And then beyond all of that, when the Southern Poverty Law Center became aware, before any indictment had come down, when they first got word that they were potentially being targeted in what they immediately recognized as a deeply frivolous and politically motivated criminal case, they didn't run. They didn't hide. They went back to the prosecutors. They went back to the people who were now pointing a criminal gun at their heads, and they said, "Here, look, let us walk you through our program all over again. Let us show you exactly what we've been doing and exactly who we've been doing it with and exactly how long this has been going on." They brought receipts. They brought documentation. They tried to head this off because the entire premise of the prosecution was provably false, and they knew it. But a whistleblower, someone currently working inside the Department of Justice who clearly still has a functioning conscience and a sense of what the law is actually supposed to look like, went to Democratic Congressman Jamie Raskin and informed him and other Democrats on the relevant committees about what was actually happening behind the scenes with this case. And Raskin and other Democrats are the only people at this point who are going to listen to these whistleblowers. Let's be completely honest about that, because Republicans in Congress have made very clear that their role is not oversight, their role is not accountability, their role is to run interference for Donald Trump and make sure that no one in a position of institutional power ever seriously investigates anything the Trump administration does, no matter how blatant or how illegal it might be. What this whistleblower told Congressman Raskin was that there appears to have been a seriously rushed indictment of the Southern Poverty Law Center, not a careful, deliberate, evidence-driven decision to bring charges after thoroughly reviewing the facts and the law and the available defenses and the public interest implications of prosecuting a civil rights organization. A rushed indictment. And according to the whistleblower account, this rush was not accidental and it was not driven by the strength of the evidence. It was part of a broader, calculated political play. The specific allegation is that Acting Attorney General Todd Blanche, who is desperately trying to cement his status as a loyal Trump servant in hopes of securing the permanent Attorney General position after Pam Bondi was pushed out, wanted to use this prosecution as a way of endearing himself to Donald Trump. Show the boss that you're willing to go after his perceived enemies without hesitation, without excessive caution, without the kind of careful legal analysis that might slow things down or result in you telling the boss that a case he once brought is actually garbage. The reporting on this from MS Now lays it out in pretty stark terms. According to the description of the whistleblower account that was obtained by the outlet, Congressman Raskin, who serves as the ranking Democrat on the House Judiciary Committee, and Representative Mary Gay Scanlon, who serves as ranking Democrat on the Subcommittee on the Constitution and Limited Government, described the whistleblower's allegations in a letter that was sent directly to Kevin Davidson, the acting United States Attorney for the Middle District of Alabama. And the letter is not subtle about what it's alleging. According to whistleblower information provided to this committee, Associate Deputy Attorney General Akash Singh ordered the U.S. Attorney's Office for the Middle District of Alabama to rush through the indictment of the SPLC, despite serious concerns about the strength of the case. Those are pretty serious words to put in a letter to a sitting U.S. attorney. Serious concerns about the strength of the case, meaning people inside the office, people who actually knew the facts and knew the law and knew the history of the SPLC's cooperation with law enforcement, had real doubts. And those doubts were overridden by political pressure from above. The letter goes further and asks Davidson to turn over all records regarding his office's use of SPLC informants and information in criminal or civil matters, going all the way back to 1996 and running through 2026. That's 30 years of documented cooperation that the letter is asking about. 30 years of records that would show conclusively whether the DOJ's core allegations against the SPLC are true or whether they are, as the SPLC and now a whistleblower are saying, completely fabricated or at minimum recklessly false. The letter also asks for all communications, including emails, phone calls, and text messages between the U.S. Attorney's Office and the top DOJ official Singh and others from January 2025 onward concerning the investigation and indictment of the SPLC. Now, Akash Singh is not just some random name that gets dropped in here. Singh is Todd Blanche's man on the ground within the U.S. attorney community. He occupies what is traditionally a very familiar post in the Deputy Attorney General's office, but under Blanche it has become something quite different from what that role traditionally looked like. Under this administration, in the hands of someone like Singh, that position has essentially become the brass knuckles enforcer role. He is the person you send in when you want to make sure that a U.S. Attorney's Office falls into line, when you want to make sure that the political priorities of the Trump regime are being executed at the ground level, regardless of what the local prosecutors think about the legal merits of what they're being asked to do. And the whistleblower is saying that Singh didn't just gently push back on concerns about the case. He didn't just encourage people to look on the bright side and find a theory that might work. He said, do it now. Get it done. Rush the indictment through. The political pressure wasn't just to bring the case, it was to bring the case immediately on a political timeline driven by the needs of people at the top of the Trump regime and not by any legitimate law enforcement consideration. And all of this is happening while current and former Trump loyalists at the DOJ are running around talking about the deep state whistleblower community that is supposedly working from within to undermine legitimate Trump federal prosecutions. That's their framing. That's how they want to talk about people who are raising alarms about cases that lack legal merit, that were rushed through for political reasons, that were built on factual allegations that the government's own prior cooperation with the defendant directly contradicts. These people aren't undermining legitimate prosecutions. The Trump federal prosecutions are undermining themselves because they are part of a weaponized plan to generate headlines, to punish perceived enemies, to capture a media cycle, and to give Donald Trump the visceral satisfaction of seeing people he doesn't like getting perp-walked or indicted on the front page. Because that's what this pattern looks like when you actually step back and examine it honestly. You grab the headline on day one, you make the big announcement, you do the dramatic arrest or the splashy indictment, you get the coverage. Trump sees his enemies being treated as criminals on the evening news, and that's the goal. And then what? Then the case actually has to go somewhere. Then prosecutors have to stand up in court in front of a federal judge and actually present evidence and make legal arguments and respond to defense motions and deal with the fact that the case they rushed through because someone at the top wanted a headline is falling apart at the seams, because it was never about winning in court. It was about the headline. And then what you see is the Trump regime DOJ suddenly becoming very interested in delay. Suddenly the case is complex. Suddenly they need more time to prepare. Suddenly there are procedural issues that need to be worked through. They need continuances. They need extensions. The case gets put on what you could only call a Trumpian litigation track, where the goal is to delay and delay and delay indefinitely while the reputational damage to the target has already been done, while the headline has already done its work, while the person or organization that was indicted is now permanently associated in the public mind with whatever criminal allegations were made against them, regardless of whether those allegations have any merit. And this is where Harry Litman from Talking Feds makes an absolutely critical point when he compares this SPLC case to the Comey prosecution that came just days later. Both of them, beside being legally empty in the most fundamental sense, beside being cases that were literally laughed at by serious members of the legal community, share this remarkable characteristic where the actual indictment says nothing of substance about the central pieces of evidence you would need to make the theory of the case work. With the SPLC, if your theory is that they defrauded their donors or defrauded the organizations they claim to be fighting against by secretly serving as some kind of asset or ally of extremist groups, you need actual evidence that the SPLC went to those groups and made misrepresentations. You need evidence that they deceived someone in a legally cognizable way. You need evidence of corrupt intent. And the indictment, apparently, has essentially none of that, because the entire factual premise of the case collapses the moment you acknowledge that the SPLC was doing exactly what every legitimate law enforcement operation does when it tries to build cases against dangerous, violent, organized groups. They found informants. They cultivated relationships. They paid people for information. They brought that information to law enforcement. That is not fraud. That is the backbone of how you build cases against the mob, against violent extremist groups, against organized criminal enterprises of any kind. The FBI does this every single day. The DEA does this every single day. Local law enforcement does this every single day. Nobody looks at an FBI sting operation against an organized crime family and says the FBI is actually funding and supporting the mob because they paid an informant who was embedded with that organization. That would be ridiculous. It would be absurd on its face. And yet, as Litman points out, the theory being advanced against the SPLC is literally indistinguishable from that logic. You had an informant program. You paid informants. Therefore, you were secretly supporting the extremist groups you claimed to be fighting. It makes no legal or logical sense. And everyone with any serious knowledge of how law enforcement actually works knows it makes no sense, which means the people at the top of the DOJ who signed off on this indictment also know it makes no sense. And that's actually the most troubling part of all of this. This isn't a situation where well-meaning prosecutors got a little overzealous and brought a case that turned out to be weaker than they thought. This looks like a situation where people knew, or should have known, given that the SPLC literally came to their offices with documentation of their cooperation before the indictment was handed down, that the factual premise of the case was false, and they brought it anyway. They brought it because bringing it served a political purpose. They brought it because Todd Blanche wanted to show Donald Trump he was willing to go after a prominent progressive organization. They brought it because getting the SPLC associated with extremism in a headline was valuable to the Trump political project, regardless of whether that association would survive contact with actual evidence in an actual courtroom. And Raskin's response to all of this is smart and targeted in exactly the right way. He's not going in asking for every internal deliberation, every privileged communication, every piece of the government's theory of the case. He knows he's not going to get that, and he knows that's not really the point. What he's going after is the specific, concrete, documented record of the U.S. Attorney's Office's actual prior relationship with the SPLC. Because that prior relationship, those decades of documented cooperation, those dossiers, those meetings, those joint efforts that led to real prosecutions of real violent extremists, that evidence goes directly to the heart of whether the factual claims in this indictment are true. And the fact that apparently none of that history of cooperation appears in the indictment and may not have been presented to the grand jury raises deeply serious questions about whether the grand jury was given an accurate and complete picture of the facts when they were asked to vote on whether to hand up this indictment. Which brings us to the question of what a grand jury indictment actually means in circumstances like this. Because you hear the MAGA commentators and the Trump loyalists pointing to the fact that a grand jury found enough evidence to hand up an indictment as though that settles the question of whether the case has merit. As though the existence of a grand jury indictment is some kind of meaningful independent check on prosecutorial overreach. And the honest answer from anyone who has actually spent time in the federal criminal justice system is that a grand jury indictment in the ordinary course means very, very little. Prosecutors almost always get what they ask for from grand juries because the proceeding is entirely one-sided. There's no defense attorney in the room, there's no cross-examination, there's no adversarial process. The prosecutor presents what they want to present, frames it the way they want to frame it, and asks the grand jurors, who are ordinary citizens with no legal training and no independent access to the evidence, to vote on whether there's probable cause to believe a crime was committed. It is not, and was never intended to be, a meaningful screen for political prosecutions brought by a government that controls what information the grand jury sees. What this entire situation really comes down to is what it means to pursue justice versus what it means to pursue headlines. Because real prosecutorial work is painstaking and careful and deliberate. Real prosecutors at a functioning, legitimate Department of Justice are not running around tweeting about their cases or holding press conferences designed to generate political coverage for the administration. They are building evidence. They are anticipating defenses. They are stress testing their legal theories against the strongest possible counter-arguments. They are asking themselves whether this is a case they can actually win in court in front of a jury that is going to hear both sides. And when they have done all of that work and they believe they have a strong, legitimate case, then they bring charges. And even then, they are careful and measured in how they communicate about it publicly, because they understand that a defendant is presumed innocent, that a press strategy designed to convict someone in the public mind before trial is both ethically impermissible and practically counterproductive, and that judges and jurors respond very poorly to the perception that prosecutors are more interested in scoring political points than in doing justice. None of that describes what is happening here. What is happening here is the pursuit of headlines as a substitute for actual law enforcement. Bring the case, generate the coverage, let Trump see his enemies being treated as criminals, and then figure out later whether the case actually holds together, or more likely, quietly let it languish on a delay track while hoping that the public stops paying attention to whether it ever results in an actual conviction. Because that's what you see over and over again with these Trump regime prosecutions. The headline is the point. The trial is an inconvenience. The verdict, if it ever comes, will almost certainly be embarrassing. But by the time you get there are 20 new headlines and 20 new enemies being indicted and 20 new cycles of outrage and political gratification for a base that wants to see the people they've been told are their enemies being punished, regardless of what the evidence actually shows. And to anyone who still thinks this is about law enforcement, to anyone who still thinks the Trump Department of Justice is operating in good faith when it brings cases like this one against the Southern Poverty Law Center or the one against James Comey, the existence of these whistleblowers, the fact that there are people inside that institution who are so alarmed by what they are seeing, that they are reaching out to Congress and to the press and accepting the personal and professional risks that come with doing that, should tell you something important. These are not disgruntled employees with axes to grind. These are people who spent their careers trying to do the work of justice the right way, and who are watching that work be perverted and corrupted in real time by people who view the awesome power of federal prosecution as a tool for political retribution. And they are doing the right thing by speaking up, even at great personal risk, because the alternative is to stay silent while the institution they devoted their professional lives to is turned into something unrecognizable. That is what a whistleblower program is supposed to look like. That is why Congress established those programs. And the fact that the Trump administration's response to all of this is to focus obsessively on hunting down the whistleblowers rather than examining the conduct they are blowing the whistle on tells you everything you need to know about where this administration's priorities actually lie.